Well, I'm a trusted person, but they seem to think it'll be okay because I started. Oh, it's that working now. Is it? Oh, great. Is anyone gone out that should be here? Or? No? Okay, great. So everybody's ready, are they?
Thank you.
Said that it's okay. Okay, I'll get the judges.
Sure, that's just that sort of just come and check.
Oh, thanks. Yeah, no, I don't need to find that.
Get us to check just in case. Yeah. That's nice.
Court rise.
Mr. Carr, I'm sorry for the interruption and the time that it's taken, but I do think these things are important.
No, absolutely.
You've got an extension beyond your 3 o'clock deadline.
I'm grateful.
Maybe.
He speaks faster than usual.
Yes, well, I think we were just going to finish up with Barnes and EastEnders. If you still have that open at page 43 of the bundle, we had just looked.
We looked at paragraph 113.
Absolutely, and I just wanted to draw your attention between G and H on paragraph 114, a couple of lines where it says modern authorities show that the courts are prepared when it reflects commercial reality to treat consideration as severable. And then over the page, there's a passage in paragraph 115 where Lord Toulson says that it's not every expectation with which a party enters into a contract that can found a claim in unjust enrichment if that expectation is defeated, because many parties enter into contracts with all sorts of motivations. And that, of course, we entirely accept. But the basis of our claim in unjust enrichment is not a subjective motive on the part of Dargamo. The basis on which we are relying is the common ground, agreed basis, that there was a bargain made between the principals. And so his lordship's observations there in paragraph 115, which I think my learned friend seeks to rely upon, are simply not in point to meet the point that we are advancing. We are not relying on subjective motives.
Well, it might be a shared expectation.
Yes.
But it might still be the case that the failure of a shared expectation doesn't give rise to a restitution claim.
Yes. Yes. And finally, the judgment of Lord Toulson wraps up at paragraph 116. I would hold that the CPS fulfilled its contractual obligations to the receiver by ensuring that the order appointing him conformed with the terms of the underlying agreements between them, but the receiver is entitled to recover his proper remuneration and expenses from the CPS, because the work done and expenses incurred by the receiver were at the request of the CPS, and there has been a failure of the basis on which the receiver was asked and agreed to do so. Obviously, the facts of our case are different, but the principle reads across in our submission with ease. So that is all we wanted to draw to your attention in that case. Now just step back from the authorities for a moment and just address a point which we've touched on already, so I may not need to labour it, but there is a theme running through Merlin and Friends' submissions, that a claim in unjust enrichment ought not to succeed in circumstances where there is a valid and subsisting contract, because he says that would subvert the allocation of risk under the contract. Now, our responses to that are, first of all, to accept that it has some force as a matter of general principle. The question whether or not the claim in unjust enrichment does cut across the contractual allocation of risk is capable of playing a role in the court's assessment of whether any enrichment is unjust. But we would submit that it cannot dictate the existence of an inflexible rule which applies in all cases, because, as we have seen, if there is a situation in which the basis upon which consideration has moved, or the basis upon which a particular part of a bargain has been entered into, has failed, even though the contract itself has not been terminated, and even though consideration has moved pursuant to the terms of the contract, you can still have a claim in unjust enrichment.
Sorry to interrupt. This morning you said you didn't need to go so far as to say that is the situation in every case. So what is it about this case that you say makes it appropriate to depart from that general principle? What is it about the facts of this case that you say makes it justified?
The fact that the basis of the payment is common ground between the parties. There was a shared expectation between the principals, and the fact that the shared expectation extends not only to the basis of the payment, but as to the amounts, which are clear from the pleadings and Mr.
But that's no more than to establish the basis. Are you saying what it's just a particularly clear basis? Is that what makes it special?
Well, I'm not saying necessarily what this is special. All I'm submitting is the combination of factors which we are inviting you to take into account to grant the remedy in this case. I don't need to go further and to say in all other cases where the same could be said, a claim will necessarily succeed.
So it's the fact that it was common ground that there was a shared expectation. Is that the factor?
That is the most important factor, and the fact that the common ground that the basis was shared, the fact that the element of the consideration that we are seeking to recover is clearly allocated to a severable part of the contract.
So clarity.
Clarity,
Because the other bits are preconditions. I mean, without those, you don't get anywhere.
Without the failure of basis, yes.
So it's the fact that it's common ground and the fact that it's very clear.
And it is clear, and the fact that what is clear is the allocation of that element of the payment to the basis which has failed. The basis which has succeeded is the 750 million for IUD. The basis which has failed is the Hyatt price and the Agro Holdings price. So it is the fact that there is a shared expectation which is clear by reference to identifiable element of the contract which is separate from the rest of the contract. The shares in NET and Agro Holdings are plainly separate from the shares in IUD, so there is a separate element in the contract, and there is an identifiable payment element which is referable to that part of the basis on which the contract was made.
In the same way as the licence fee or the tax was a separate element which was clearly identifiable and determinable in Ruthven's.
Exactly so. And that was going to be my next point in relation to this, in relation to the question whether or not the fact that a contract allocates risk is a complete answer. That submission can't, with respect, survive in the face of Roxburgh and Barnes, because those were both cases in which the contractual outcome would not have, the contractual route would not have produced recovery in Roxburgh for the retailers or in Barnes for the receivers. So unjust enrichment was expressly being deployed in order to produce a remedy, which the contract did not produce. That was the whole point of bringing the claim on that basis. And we do submit the other point of distinction that is perhaps helpful in answering my Lady Justice Carr's question, is that allocation of risk makes at least some sense when you are talking about risk as between the contracting counterparties. But here, there is a mismatch between the contracting counterparties who actually signed the Castle Rose Agreement and the principals who agree the bargain on which we are relying. The principals, and this is, as we saw, one reason why the application of English law didn't work in relation to the claim based on the 2009 shareholders agreement, because the parties to the bargain were the principals, Mr Taruta, Mr Gaiduk and Mr Mkrtchan, whereas the allocation of contractual risk operates as between Avonwick, Dargamo and Azitio. So that, in our submission, is another important factual point, if I need to make out something special, so to speak, that marks this case out from others. it is the mismatch, so to speak, between the parties who are bound by the contractual allocation of risk and the true parties who entered into the bargain, which defines the basis upon which the mere corporate vehicles entered into the contract. Related, and again a point that we have touched on, is the process by which the court actually identifies the basis of a particular payment. My learned friend would say the court must and can only look at the terms of the contract itself. We would say, for the reasons we've seen, looking at Roxburgh and Barnes, that is not so. The basis of a bargain, the basis of a particular payment, is not necessarily limited to the contractual counter-promise. So you are not limited to looking at the contractual terms in order to identify what the basis of a payment is. So for reasons of authority, Roxburgh and Barnes, we would submit that Malone Friend's argument in relation to confining the court's attention to the terms of the contract in order to identify the basis of the payment, that argument is unsustainable. And we would also, if we needed to, we would also urge on you that there is no reason in principle, even irrespective of authority, there is no reason of principle to confine the court's assessment of the purpose, the reason for, the basis of a payment, to be confined to the actual terms of the contract itself, because by definition the claim in unjust enrichment is a claim which has a life, as we just saw from that passage, more akin to the world of tort than to the world of contract, in which what matters is the contractual counter-promise. And one sees something of this. There's just one other case I just wanted to spend a little bit of time on, which helps on this, although in fairness, I said before we go to it, the case is Guardian Ocean Cargoes. It isn't a case ultimately in which a contract was made, but what it says in terms which in our submission support the approach that we do derive anyway from Roxburgh and Barnes, that you look at when you're assessing the basis upon which a payment is made. The court is making essentially an evidential assessment. That's what the trial court does. And one gets that from the decision, as I say, in Guardian Ocean Cargoes, which is in the second authorities bundle at tab 6. As I say, it's not wholly in point, because ultimately there was no final contract entered into. The facts of this case, I don't know if you've had to look at it ever before, the facts of this case were that there was a shipbuilding contract financed by a bank. The owner of the ship defaulted on various promissory notes which were payable to the bank, and so the charterer stepped in and got into negotiations with the bank, and the charterer started making payments to the bank to keep the bank happy while those negotiations went ahead. The negotiations ultimately did not result in a refinancing deal. So the question then arose between the bank and the charterers as to whether the charterers had been paying as an advance which was recoverable if no refinancing deal was ultimately agreed, or, as the bank argued, whether the charterers were paying in discharge of the owner's default on the promissory notes. And
so that their only remedy would have been to claim back from the owners?
Yes. Yes, exactly so.
Who weren't receiving.
The decision in the Court of Appeal starts at page 344. I just wanted to pick it up at 347, which shows how the point was argued and then decided. So in the right-hand column on 347, towards the bottom of the page, Lord Justice Saville says that the bank's argument was that the payments were outright payments, not dependent on the bank agreeing to the refinancing, but simply by way of an out-and-out partial discharge of the obligations of the owner under the promissory notes, and that the payments were therefore irrecoverable. The claimant's argument was that the payments were made on the basis that they would form part of a refinancing deal with the bank, and that since no such deal was ever concluded, they are entitled to their money back from the bank. Mr. Justice Hurst, as he then was, preferred the plaintiff's arguments, and so do I. And then we get some recitation of the argument. You'll see, just staying on the left-hand column without reading the whole thing, the left-hand column, there's the penultimate paragraph, just over halfway down, starts Miss Gloucester further submitted. And then halfway through that, there's a sentence beginning, as to Mr. Petropoulos, who also gave evidence, Miss Gloucester repeated these submissions, but added to them the further argument that all or virtually all of Mr. Petropoulos was able to say related to his subjective intentions and was therefore of no assistance. No oral evidence was given on behalf of the bank of the discussions with Mr. Eukem. As to the first of these points, the learned judge took a different view, particularly the evidence of Mr. Eukem. He said this, in my judgment, this analysis is unsound. I'm quite satisfied that when, in his written statement, Mr. Eukem referred to goodwill payments, payments for a specific purpose, payments as a sign of good faith, and the like, he was intending to refer to the payments being conditional in the above sentence. This interpretation was strongly enforced by his evidence and cross-examination. And having listened to him carefully throughout his evidence, I am completely unable to accept the suggestion that the intentions which he described above were merely private between him and Mr. Petropoulos. It was abundantly clear from a large number of passages which I have quoted above that he was referring to the position as between the plaintiffs and the bank, with he himself being the intermediary in direct touch with both of them. I am therefore satisfied that his evidence, if accepted, fully supports the plaintiff's case. And the same goes for Mr. Petropoulos, though of course his evidence is much less important because he's not in direct touch with the bank. So there we have the countervailing arguments, that what was being said as the basis was the bank was saying just subjective intention, and Mr. Justice Hurst, as he was then, saying no, it was a shared understanding on the evidence. And one sees the Court of Appeal accepting that on the next page, 349, right-hand column, first complete paragraph. The learned judge, having had the advantage of seeing Mr. Eukem and Mr. Petropoulos giving evidence, formed the view that their testimony should be accepted. I can see no grounds at all for interfering with this conclusion. I agree with Miss Gloucester that in a case such as the present, the understanding or agreement of the parties must be ascertained objectively, and that the parties' uncommunicated subjective thoughts cannot be called in aid. But on this basis, I am satisfied that on the evidence, the learned judge was right to conclude that the payments were conditional. So what the court is there doing is accepting the approach taken by the first instance judge, which is that the basis upon which a payment was made was to be ascertained as a matter of evidence, not subjectively by reference to the motives of the payor, but objectively by reference to the common understanding of the parties. And the Court of Appeal accepted that the trial judge's findings on that basis were incapable of being overturned on appeal. And that is why I read you those paragraphs in the 700s of the judgment, where the judge below accepted Mr. Foxton's submissions as to the common ground upon which the additional sum, as the judge said, was paid in this case. That was the common understanding in this case. There are a number of other cases that are mentioned in the judgment below and in our skeleton, which are other sort of illustrations of deposits being paid towards, in anticipation of a binding contract being entered into in due course. and then a binding contract not being entered into, and the deposit being recovered. We've got
The simple sort of Chillingworth and Ash situation.
Exactly. I wasn't going to go to those. I mean, in the abstract, I don't think the principle is remotely controversial. The only question is whether that principle applies in circumstances where the expectation pursuant to which that advance payment was made, it exists, so to speak, outside the terms of the contractual face of the Karlsruhe's SPA in this case.
That's why I described Chillingworth and Ash as a simple situation.
Yes, absolutely. The only particular point, we've made this in our skeleton, but I'll just mention it again, the only particular point that one does get from Chillingworth and Ash is the fact that if ultimately a party withdraws from the anticipated contractual negotiations and there isn't a binding agreement, he isn't deprived of his ability to recover the advance or the deposit paid, simply because it might be said that the contract wasn't completed through his own choice. It's not a blame game, and one sees that clearly from Chillingworth and Escher. The court is not sitting in judgment on why the concluded contract wasn't entered into. And that element of Chillingworth and Escher is relevant in this case, because I know my learned friend has mentioned that there was a contract offered in relation to Agro Holding, but my client didn't complete it in the end because he didn't want to pay the technical consideration because he wasn't sure he was going to get it back. But that is an irrelevance. Our claim in unjust enrichment is not defeated simply because my client chose not to enter into the particular bargain. That doesn't deprive him of the right to ask for back the advance that was paid in relation to.
I'm just reminding myself, the judge didn't have to deal with this. Do the respondents take a point on the SPA, or on the 2011 Agro SPA?
I had thought that they did, but we'll no doubt share.
Yes.
The only other authority I just did want to go to, it deals with the question of apportionment, because, as I said, one of the distinctive characteristics that one is looking for, and which we say is satisfied in this case, is the ready ability to apportion an element of the single contractual payment to the particular basis which has failed. And the leading case that deals with the English court's attitudes to the apportionment of a single contractual payment is a decision of Mr Justice Stadlen in Guido Vandergaard and Force 1 India. And that is in the first authorities bundle at tab 5. Again, it's a bit of a monster of a judgment, so I just wanted to walk you through some very short passages in it. The dispute arose. Mr Vandergaard was an aspiring Formula 1 driver, and he established a management company to manage his driving career. Force India, Formula 1 team, ran a Formula 1 team, and I think it's actually been bought and is now Aston Martin branded. But anyway, it's the deal was that a payment of 3 million, single contractual sum, was due under a service agreement and a fee agreement, which had a large number of different elements. One of the main elements was that the Formula 1 team was to provide this aspiring driver with a minimum of 6,000 kilometres of practice driving in a Formula 1 car. And there were various other elements such as branding on the car and on the driver's outfit and helmet, paddock access cards and all that kind of thing, but also other sort of slightly more complicated driving rights to test the car on a Friday morning, which is obviously before a race, a much more high-profile thing, and the right to act as a reserve driver on race days if the driver got his super license to drive in Formula One. Ultimately, what happens is that the driver and the Formula One team fall out. The driver and his management team sue, alleging that the Formula One team has acted in breach of contract by not giving him the 6,000 kilometres test driving, only just over 2,000 kilometres. So a claim is brought for unjust enrichment. And essentially what the driver and his management company are seeking back is a proportionate chunk of the 3 million payment. So there's quite a lot of detailed consideration given to the circumstances in which the element that has failed, the failure to allow 4 of the 6,000 kilometres of test driving, can be apportioned to the element of the payment which has been made, which the driver and his management company are then asking for back. It's quite complicated on the facts, but if we could just so that you can see where the matters are all dealt with, at page 207.
The hearing lasted 18 months, or it spanned 18 months.
I think part of the trouble was that the defendant's counsel died
Yes.
and had to be replaced by Mr Sergiy.
Yes, that's absolutely right. Yes, John Davis, Queen's Counsel. Yes.
207.
207, I'm grateful. Paragraph 234. If I could perhaps just beg your indulgence till about 10 past.
Absolutely.
Thank you. Paragraph 234, under the heading Claim for Restitution, the judge identifies 2 principal questions. First, does the fact that the defendant permitted Mr van der Gaard to drive 2,004 kilometres mean that the failure of consideration was partial rather than total, such as to exclude the availability of restitution? Second, if and to the extent that other benefits were received by Mr van der Gaard, does that fact and or the fact that the consideration payable under the fee agreement was intended to cover additional benefits to the claimants preclude the availability of restitution? And then over the page, paragraph 236. If I could recommend the whole of that to you, but he talks there about mitigating principles which have evolved that govern the treatment of incidental benefits and benefits that can be apportioned to discrete parts of the consideration paid and payable. And about just over halfway through the paragraph, he says the second allows for the apportionment of consideration between benefits so that even where some benefits have been received pursuant to a contract, it can be said that although there is not a total failure of the entire consideration due to pass under the contract, there has nevertheless been a total failure as to a part such that restitution is possible. That principle is then explored in some detail. If I could just invite your attention, there's quite a lot of recitation of argument, but the decision itself really starts at page 216. And it's from paragraph 261 onwards that the decision picks up. If I could just, without labouring too much and getting into too much detail, in paragraph 262, about halfway down, there's a line beginning with ... money had and received, and the quote continues, money had and received to the plaintiff's use can undoubtedly be recovered in cases where the consideration has wholly failed, but unless the contract is divisible into separate parts, it is the whole money, not part of it, which can be recovered. If a divisible part of the contract has wholly failed, and part of the consideration can be attributed to that part, that portion of the money so paid can be recovered. But unless this be so, there's no room for restitution under a claim in debitatis assumpsit. And as I say, I would recommend all of that and the next paragraph, but I just wanted to draw your attention to the last 4 or 5 lines of paragraph 263, where it is possible to apportion different parts of a contractual price to the performance of different contractual duties under a contract. It is not, in my judgment, inconsistent with the proposition that there may be a total failure to perform contractual duties in respect of which payment is due, that there has been performance of part or all of contractual duties in respect of which the payment is not due. Now, just to anticipate, my learned friend will point out that Mr. Justice Stadlen in this case was considering the question of apportioning different parts of a contractual payment to the performance of different elements of the contractual counter obligations. And I entirely accept that is what he was talking about. But if you are with me on the Roxburgh-Barnes analysis that the failure of basis is not limited to, and this is what they say, is not limited to an analysis of the contractual counter-promise, then the approach that Mr. Justice Stadlen took to apportionment it should apply to the failed basis, which is not itself a contractual counter-promise. So in our submission, read that last paragraph, that last half of paragraph 263, as applying to the circumstances in which what he's talking about is the failure of the basis on which a part of the payment has been made. We can then just very quickly go on to page 229, where you'll see that his discussion of apportionment begins in detail at paragraph 292, last 2 lines on the page. And you'll see there's discussion from there on. It's really through from the bottom of 229. Really, it goes on for some considerable time to the end of paragraph 323. So I'm certainly not going to attempt to read all of that. But if I could just draw in those paragraphs, if I could just draw your attention to a couple of passages. Paragraph 297, the court is discussing the case of Goss and Chilcott, which is quoted at length in paragraph 295. So Lord Goff in Goss and Chilcott's over to dictum. So Goss and Chilcott was the case in which a loan agreement had been held to be unenforceable. The capital sum was reclaimed by way of unjust enrichment, and the question was whether or not that claim was defeated by various interest payments which had been made in the meantime. And Lord Goff had expressed the view obiter that even if part of the capital had been repaid, there would still have been a claim in unjust enrichment to recover the balance of the capital. And commenting on that, Mr. Justice Stadlen says, moreover, Lord Goff's obiter dictum that even if part of the capital sum had been repaid, the law would not hesitate to hold that the balance of the loan outstanding would be recoverable on the ground of failure of consideration was not expressly conditional upon the existence in the hypothetical contract in this example of express or implied terms stipulating separate obligations to advance and repay each distinct instalment of the loan advanced. This perhaps suggests that it was not Lord Goff's view that apportionment is permissible only where it is expressly or impliedly provided for in the contract. Indeed, his conclusion that the law will allow partial recovery, at least in those cases in which apportionment can be carried out without difficulty, suggests in my view that the question whether apportionment can be carried out turns not on whether apportionment is provided for either expressly or even by implication in the contract, but rather on whether, as a matter of practical common sense, the court considers that it is able to apportion an objective analysis of the nature of the contract and the consideration. And that is the approach that we urge on you, one of practical common sense as to whether it is possible to apportion to the failure to enter into the agro-holding and NET transfer agreements, Dargamo's payment towards those elements that we have seen in the pleadings and the evidence. Again, one sees that at the very bottom of 299, last few words on the bottom of page 232. In a case where, to use Lord Goff's language in Goss and Chilcot, apportionment can be carried out without difficulty, there is no reason why the court cannot conclude that even where contractual duties have been performed by the payee, they are not contractual duties in respect of which the relevant payment is due. And again, the answers to the battle lines are very clear. My learned friend will say, well, the full 950 million was a payment in respect of the shares in Castle Rose. We say that's what the contract says on its face, but that isn't in reality what the bargain was. So with those legal principles in mind, essentially we simply say that the case in front of the judge at trial was one in which the Gaiduk parties had brought a claim alleging deceit on the basis that the price, their word, the price for their interest in IUD was 750 million.
They bought an alternative. I mean, that's because it gave them the most reward.
Yes.
They did run the alternative case, didn't they? If contrary to their primary case. But I understand that doesn't necessarily undermine your point.
They also, I think they saw the wind in closing. I mean, I didn't do the trial, but as far as one can tell from the transcript, they could tell that the deceit claim was not going entirely according to plan. And so in closing, seeing also that the unjust enrichment claim might actually have more legs than they originally thought. In oral closing, counsel then appearing for the Gaiduk parties did say, oh, of course the contract does say that the consideration is 950 million and therefore the consideration is 950 million. So there was a forensic bit of footwork there. But the fact is that the pleadings remained the same and the evidence remains the same. And that is the basis upon which we are asking this court to proceed. As I say, I've taken you to the pleadings, to the evidence and to the way the cross-examination came out. And it is entirely clear in our submission on that basis that the Gaiduk parties have been enriched. They've been enriched at the expense of my client. And that enrichment is unjust because it is clear that the basis of the payment elements of 75 million for the NET interest and 7.5 million for the Agro Holdings interest were payments made in respect of a basis which has wholly failed. As I say, the battle lines are very clear. The learned friend will say the contract reigns supreme. If you accept that argument, we lose. But we would submit that the authorities on which we rely clearly support an outcome which entitles you, and we would say rightly, to reach the conclusion that it would be unjust for the Gaiduk parties to come to court alleging what the basis for the calculations were, but then not being held to the consequences of that by paying back the element of the consideration that has passed to them in respect of a benefit which hasn't been realised in my client's hands. We are not, we submit, asking you to make any new law. The parties are agreed that there are exceptions to any general assumption that you can't maintain a claim in unjust enrichment where there is a valid and subsisting contract. The only argument between the parties is as to the scope of the exception to any such general rule. And we submit, particularly, as I say, in circumstances where the allocation is clear, the agreed basis of the payment is clear, and the fact that the parties to the bargain are not identical to the contractual counterparties, those three elements come together to make this a claim which should be allowed to succeed.
So you're saying that the deal between the three principals was or included that the Gaiduk interest in IUD would be sold for 750 million.
Yes.
And that the Gaiduk interest in other assets would be sold at a price of, and we've seen the two that we're interested in,
Yeah.
but there were others. Yeah. That the Castle Rose agreement was entered into deliberately and not subject to any error such as rectification could deal with, in the terms in which it was, providing for only the sale of the shares, but at a price which reflected the understanding as to the price of other assets.
Yeah.
And what should have happened is that the other assets should then have been transferred, maybe pursuant to new agreements, but without any separate consideration other than whatever might have been required by Ukrainian law. And it's the failure to get to that stage that, so far as your clients are concerned, constitutes the failure of basis.
Yes. Exactly so.
Unless there are any questions from the bench, those are my submissions in opening.
Thank you very much.
No, thank you very much, Mr. Gray. Mr. Rubenvitz.
Ladies, my lords, as the court knows, we respectfully submit that the learned judge was right to reject the appellant's claim in unjust enrichment for essentially the reasons he gave. I'm going to take you to the contract again because, as my learned friend kept saying, and he's right, this really does turn on the contract. And I'm going to explain why. But can I just say this? My learned friend submits, that if this court decides in his favour, you will not be creating new law. In my respectful submission, he is completely wrong about that. If this court decides this case in my learned friend's favour, this court will be rewriting what I would respectfully submit is a key tenet in the law of unjust enrichment. And I'll come to that.
That's the restatement.
The restatement?
The key text, or test?
Text.
Text.
Tenet. I actually think I said tenet.
Tenet.
But
Right, my fault. Thank
it's
you.
also text.
All right.
It's also in the authorities.
Yes.
As I shall show you, the academics have spent a long time trying to understand the Roxburgh case, because of course it isn't English law. And although my learned friend cites it as if it is, it isn't. And there is a strong academic view that it is wrong. For exactly the reasons I'm going to submit. And even those who say it isn't wrong confine it in a way which would really not assist my learned friend.
So there's the preponderance that says that it's correct, but on the basis it doesn't conflict with the sanctity of contract, or the public policy of allocation of risk. So that's the analysis. And those who say it's wrong say, no, it does conflict with that policy. And is that why you say either way it doesn't help?
I would take slight issue with the preponderance of academics saying
You may have to count them up.
It depends how you count Professor Beetzel or Sir Jack Beetson,
Yes.
because he wrote the original article analysing Roxburgh and trying to explain that Roxburgh could be understood as a case which was consistent with the basic tenet of unjust enrichment, that it doesn't cut across contract. It doesn't cut across contractual allocation of risk, by saying that in that particular case, the particular extreme facts of that case, that you had an externally imposed element, namely the tax, didn't undermine any of the principles which were relevant to this principle about unjust enrichment not undermining contract. I'm going to take you also to, I'm sorry to spend a little bit of time saying where I'm going to go, otherwise I'll just take you to the contract and sit down. But I'm also going to take you to another Australian High Court authority which follows Roxburgh. You'll have seen it in the reading list, Mann and Patterson, which is, in my respectful submission, a very important authority, because that authority expressly makes 2 points, which I'm going to emphasise. Number one is the subsidiarity role played by unjust enrichment as compared to contract. Unjust enrichment is a gap filling, and I don't mean that in a pejorative way. I wouldn't As the court knows, I have been very involved with unjust enrichment over the years, and I love it dearly. But the reality is we work on the basis that it is a gap-filling part of the law of obligations. It is subsidiary to and never contradicts or undermines the law of contracts, which has a superior place, if I can put it that way, in the law of obligations. So that's the first point Mann makes, and there's a beautiful heading in Mann which basically says the subsidiary nature of unjust enrichment as compared to contract. The second point which emerges from Mann, and one will see it, is that the court makes absolutely clear, expressly clear, that the role of unjust enrichment is not to cut across, undermine, contradict what the parties have agreed in the law of contract. And when we get to Roxburgh, I'm going to submit that that was not a case in which the court found anything which was inconsistent with or contradictory to what the parties to the contract had agreed. And you may recall from Roxburgh that we focused a great deal of attention on paragraphs 1 to 18 of that authority. The reason for that, and we also referred you to the federal court, is because a great deal of time and trouble was spent trying to explain why the contractual documentation actually made it clear that the tax element was a separate element in terms of the consideration, so that you could have a failure of this externally imposed basis without there being any problem with undermining the law of contract. My learned friend at one point in his submission complains. He says, we are bringing in to the analysis externally imposed obligations. With respect, a paragraph that he didn't show you in Roxburgh, paragraph 23, that is the language that the majority there used. And the reason they use the externally imposed language to describe the obligation, no, it's not an obligation, that part of which was paid, which was going to be repaid, is to make the point that they were not in that way undermining what the parties had agreed. In other words, they were not in that way, in any way, contradicting the contractual allocation of risk. Now, I ought, I'm sorry.
Sorry, and so the platform, you'll develop this, paragraph 23 is the basis for those who think that Roxburgh was not objectionable in terms of offending the contractual allocation of risk. And yes, that was
well, let me make this point, because it'll save time when we get to Roxburgh. Of course, the majority is made up of a judgment of 3 of the justices and then Justice Gummo, and you have Justice Kirby dissenting. The difference between the majority and the minority in that case, and I include Justice Gummo in that majority, is that the majority thought you could, by looking at the contractual documents, and indeed by finding that it wasn't a single contract that you were dealing with, that you were actually dealing with a series of contracts which were made on a particular basis, you could find that the tax payment, the license payment, or the contribution to the license payment, was separate and distinguishable from the rest of the consideration paid for the tobacco. Justice Kirby did not think you could do that. He thought you could not break up by looking at the contract. And this is what both parts of the court were doing. They were looking at the contract and the contractual documentation and trying to ascertain whether you could break it up so as to not undermine the contractual obligations. And the distinction between the two was that Justice Kirby thought you couldn't do that, and the majority thought that you could, without undermining, subverting, I'll use that word again, the contractual allocation of risk, the agreement made by the parties. And that is precisely why we find, for example, Professor Beatson changing sides in the debate, originally saying there may be an exception, but actually Roxburgh is wrong, when he writes with Professor Virgo about this, not recanting, he doesn't say he's disagreeing with what he'd said previously, but he was the one who originally analysed Roxburgh and thought, isn't this an important case? And that is why Goff and Jones thought it was wrong, because Goff and Jones' view is that it is undermining that basic tenet of the law of unjust enrichment, that you do not undermine or subvert contractual risks which have been allocated between the parties. And that is precisely what, in my respectful submission, the appellants are urging this court to do. Now, I again want to be clear about what I'm not saying. I am not saying, let me start from a slightly different place. My learned friend in his submissions identifies the bank financier analysis of the elements of a claim in unjust enrichment. Enrichment at the expense of and an unjust factor. Of course, some people regard the fourth, absence of defences, as a fourth one. That has been adopted by Lord Burrows, by Burks, by everyone.
And is that Lord Burrows in Somersand?
I beg your pardon?
Is that Lord Burrows in the Somersand case or different case?
It would have been Lord Burrows in the Somerset, but he has been making this point in his writings
yes,
forever.
but judicially.
Judicially, indeed. But it goes back to bank financier. It goes back to Lord Stone in bank financier. And in Sempra and in Deutsche, Morgan, all of the cases have identified those three principles as being the relevant principles. My learned friend identifies them, and with that I cannot disagree, and I don't disagree. Where, with respect, I depart from my learned friend is in his suggestion that because this is now called unjust enrichment, I think he said the clue is in the name. With respect, the misleading clue is in the name. Because this isn't about the court sitting back and saying, is this unjust, or is this fair, or is this equitable? The courts have disavowed that kind of analysis. This is a common law remedy. And I think my Lady Justice Carr made the point to my learned friend. We are talking about unjust factors. And when, and this is clear in a page from the restatement, the Burrows restatement, which sadly did not make it into the bundle, because I didn't know my learned friend was going to try and introduce what I would regard as a quite controversial proposition. But in page 31, which is the page before the Burrows extract from the restatement that you have, as he's writing, Professor Burrows and his panel make the point that the unjust reference there is to unjust factors. It works in exactly the same way. I'm sorry. There was also a reference in Barnes to Goff and Jones, which my learned friend took you to, I think it was paragraph 102 of Barnes, where Lord Toulson cites from Goff and Jones. And my learned friend cited for a proposition which he said was in his favour. It wasn't, but that's not the point I'm on. If you look at what he said there, again, where it's comparing unjust enrichment to tort, the point which is being made is in fact the same point that I'm making. There are categories where you have a claim.
It wasn't saying it's like tort, not contract. It's saying that it's the process of development of the relevant
Precisely.
outcomes.
By reference to unjust factors. So
Categories.
Categories. So when my learned friend criticises us for saying, oh, there are these rules, and you should apply the rules and identify the exceptions to the rules, with respect, he's right to say that that is what I say. Because that's how the law of unjust enrichment, which is a common law claim, works. It is not about sitting back and saying, is this fair, is this just? One identifies categories and one says, does this come within this category? And of course, it is open to the court to expand the categories. Nothing's inflexible in law. Nothing. If I ever said there was an inflexible rule, I know I'd lose. So I don't suggest inflexibility here. If you stand back and you ask in relation to the claim that my learned friend is making, just stand back. A payment of $950 million has been made under the Castle Rose SPA, and it is said on the face of it that it is made for shares. So $950 million was due and payable under that contract for shares. That is what is in part the subject of this claim in unjust enrichment. When you ask whether anyone has been enriched, as I shall show the court, one of the things that the courts, one of the points that is made in the law, and this is a point expressly made by Lords Briggs and Sumption in the DD Premium Growth Fund case, is that you cannot have a claim in unjust enrichment where the payment discharged a debt which was due and owing. Because if it did, there is no enrichment. The learned friend doesn't appear to dispute that this was a payment which discharged a debt which was due and owing, nor can he. Because there was $950 million identified in the Castle Rose SPA as payable for the shares. With respect, that is the end of his case. Now there is a further point which arises about failure of basis. And I'll obviously need to develop this. Again, I do not dispute that one of the unjust factors that exists in the law of unjust enrichment is a failure of basis. Nor do I dispute, although my learned friend appears to suggest that I do, that in identifying the basis which may have failed, you are not confined to looking at promissory consideration. I do not say that you are.
Yes, so the scope of inquiry point, you don't say, will you accept as Mr. Crowe submitted? Self-evidently, in order to look at, to see if there's an understanding or basis, you have to go out for the purpose of an unjust enrichment claim. If a basis is asserted, as it is here, you have to go outside the contract to see whether there is that basis.
Can I take it in stages?
Of course.
At this stage,
Sorry.
at this stage, what I'm saying, I accept, and I'm not sure that the learned judge accepted this, which I think is why my learned friend makes the point. But I certainly accept the point, nor could I dispute it in light of Barnes or Roxburgh.
I'll be quiet. But sorry. So you say in identifying
the basis which may have failed, you are not confined to looking at the consideration payable, the promissory consideration payable under the contract. And that's clear from Barnes itself. Because in Barnes itself, when one gets to Barnes, one sees, on the one hand, the receiver was saying, well, I'll do what receivers do. And the CPS were effectively saying, we request you to do this. But there wasn't a consideration which failed, as between them, a promissory consideration. So you had to find a basis which failed. And again, I'm not going to, I couldn't, but I wouldn't begin to suggest that Lord Toulson was wrong in that case, that there was a basis that failed. What is important with respect about that case is that the basis that failed was obvious from the contract. You look at the terms of the contract and it is absolutely obvious that the basis upon which the parties have contracted is that the receiver will be paid out of proceeds of the lien, and that there will be a lien. What makes this case, with respect to an extreme one, so far as the lien is concerned, is that he not only wants to go outside of the contract to find a basis, he wants to find a basis which is flat bang inconsistent and contradictory with the basis for the payment set out in the contract itself. There has never been a case in which that has been done. Nor with respect does the law of unjust enrichment contemplate that possibility, because that would be denying the subsidiarity role of the law of unjust enrichment. That would be the law of unjust enrichment rewriting contractual bargain. So I accept that one is not confined to promissory consideration, but what you can't do, and I accept,
but do you say it's confined to a basis that is obvious from the contract?
With respect to what I'm going to say, in my respectful submission, there hasn't been a case where it hasn't been confined, but I'm not going to say you couldn't imagine a case in which it could not be found.
But it's not this case.
Well, A, it's not this case, and B, even if you could go outside the contract, what you could never do is assert a basis, apparently between different people now, because my learned friend's case has moved around, in my respectful submission, because he knows he can't deal with this point. So now, suddenly we have a basis, which is not even the basis between the contracting parties, which is not even the basis between the parties who have made the payments, which is not even the basis between the parties who have received and apparently been unjustly enriched, but a basis between different people. And in my respectful submission, if that is permissible, and with respect I greatly doubt it, you cannot find a basis which contradicts the stated basis in the contract for a payment. And that's, in the end, what I'm going to start with saying, and it's what I'm going to end saying. I'm afraid it's all downhill from here. But, that, in broad outline, is what we say here. And so, and with respect, again, I'll say this and then get it all out. I've been waiting to say this for a few hours. Although it is fair to say that the learned judge made a series of points, some of which were not entirely on point. Paragraphs 808 to 812, and again at paragraph, I think it's 820 to 824, he, if I can use this language, nailed the point. 820 to 824 is when he's dealing with the deposit cases. The early part is where he's dealing with the ordinary failure of basis cases. He makes the point repeatedly that he simply cannot see how a claim in unjust enrichment can lie in circumstances where the payment is made pursuant to a contractual obligation to make the payment and where that contract has been performed. It's not about finding a breach or saying you could only have a claim in unjust enrichment where there's a breach of contract. He's making the point, how can you say that the basis for this payment is failed, where the basis for the payment is identified as being all the shares, and you have the shares? And he makes that very clear. Again, in the context of the deposit cases, a similar point arises. When only ever gets to the deposit cases are not, they all involve cases where a payment is made not pursuant to a contract, but it's made in anticipation of another contract. And if there wasn't a Castle Rose SPA, then with respect to my learned friend, he would have a very good claim here for unjust enrichment on a Chillingworth basis. But the point that the learned judge makes, and this is between paragraphs 820 and 824, is that this case is different. Because here the 950 million was made pursuant to a contract. It wasn't like Chillingworth, New Line, and Ocean, whatever the case is. And he's making exactly, with respect to the point that I'm endeavouring to make to your ladyships and your lordships. Can I then, again,
Down to the contract.
down to the contract, if I may. So supplemental bundle, tab 5, page 61. Clause 2, and the learned friend has taken the court to this. Clause 2.4, the consideration for the sale of the shares shall be 950 million. And the reason I take the court back to him, my learned friend says my case is the contract says, the contract says, the contract says. He's right, it does. And that is my case. But the point is this, it identifies the basis for the payment of the 950 million. It explains the reason why the 950 million is being paid. And that's why it matters. And unless the law of unjust enrichment is going to cut across, undermine, subvert the contract, we have a basis here, and it hasn't failed. He has a competing basis arising out of what is said to be a common intention. That may well exist. I'm not going to take issue with that. But whatever the status of that, it can't contradict or undermine the stated basis here.
So you say even if we're entitled to look at the evidence, the pleadings, and all the rest of it, and say that there was not only a common understanding in principle, but actually even an understanding, a precise and concrete understanding as to 15, whatever it is, whatever the figures are.
15 plus 75.
Yes.
Or
Then
75.
you say, even if you take all that in the appellant's favour, it doesn't get you anywhere.
Gets you nowhere.
Because on the facts of this particular case, if one understands the proper role of unjust enrichment, it just doesn't work.
Exactly. And Sir Timothy made a point to my learned friend when summarising the learned friend's case, which is that the parties knew and deliberately entered into a contract which said what it said here.
Well, that's paragraph 662, which Mr Crowe hasn't addressed.
And also paragraph 823.
823.
Where the learned judge makes the point, if you deliberately construct your affairs in contract on a particular basis, you really can't complain if you're held to that basis. And so, with respect, it matters that this is a deliberately constructed contract, which has, as 950 million, identified the basis for that payment being the transfer of the shares. My Lady Justice Carr put to my learned friend, if what you're saying is right, why didn't you seek rectification here. And my learned friend wasn't able to answer that question. And nor with respect to Kenny, he couldn't have got rectification here because this was deliberate. My learned judge
I
said
see
so.
what you mean, yes.
It wasn't a mistake.
No, I understand.
Now, it was a very important question to ask, because if my learned friend's case was going to be, although it says 950, that's not really what we agreed. We, as principals, and he draws this distinction between the
But
principals.
that is what he's saying, in a way.
Yeah.
Sorry.
What he should do, what they should have done, is to say, we need to rectify this contract. We need to rectify the contract to make it clear that the 750, it's only 750 for the shares, and there's some other things which are being thrown in. They didn't do that. I'm not sure it was explored why. There could be tax reasons, there could be exchange control reasons. They did this deliberately. And so if one ever gets to fairness, I'm not sure, and courts I know are always concerned about fairness. The question is it unfair to hold on to what they agree to for whatever reason they agree to? Now,
And so you would say they did what they did and they intended to do it. Okay, the agreement was made between their corporate vehicles, but nevertheless, that's what they intended to do. And the fact that they had reasons for doing it is neither here nor there.
neither here nor there. If they were good enough, if they were concerned that only 750 should be for the shares, it's very easy with hindsight to say this, but there ought to have been a rectification claim. There couldn't be, because this is what they deliberately intended the contract to say. So they have that...
and nor conversely, could there have been rectification to say that what you get for your 950 million is not just the shares, but other things?
Indeed. Because this is what they wanted. This wasn't a mistake. One assumes it wasn't, or the judge finds that it wasn't a mistake.
And equally, you can say it makes no odds how they got to 950 million.
Exactly.
That is the figure.
Exactly.
And that is the figure as the price for the shares.
Exactly. And with respect, exactly. And one can speculate as to why it suited them to do this. And I have. As I say, it may be exchange control, it may be tax. It doesn't matter. This is the way they decided to arrange their affairs, and they did it deliberately. Now, you'll have seen that we refer to the entire agreement provision. I don't have a whole different argument based on it, and that's why I was quite cautious when standing up to say, we are not relying on it. It's in the contract and it is relevant. And the reason it is relevant is if we go to page 68, this deed and the other transaction documents, which I'm told are minutes and the like, contain the whole agreement between the parties related to the transaction contemplated by the transaction documents and supersede all previous agreements, whether oral or in writing, between parties relating to these transactions, except as required by statute, no term shall be implied. Each party acknowledges that there are no collateral contracts, etc. So they want this to be the only contract to govern their affairs. They don't want there to be collateral contracts. What the learned friend's actually suggesting, he makes two suggestions. Number one, he says, but the understanding was between different persons, and therefore they're not affected by that. With respect, in my respectful submission, there is no distinction in the context of these parties between their corporate entities and these individuals. They were using the corporate entities as part of their, just as a mechanism for doing what they wanted to do. As I say, it is an argument which doesn't emerge until my learned friend stands on his feet. I'm sure he can point to some paragraph in his skeleton argument which says it's foreshadowed. But that is an argument that gives him some difficulty, because he's trying to identify a basis between persons who are not parties to the contract and trying to rely on a failure of a basis between those persons not parties to the contract to undermine a basis identified between the persons in the contract under which the payment was made. Unless he is saying, which is even worse, that actually his claim is by I think his client is Mr Taruta, because it's Mr Taruta who has the claim in unjust enrichment. Again, that would be hopeless, because Mr Taruta didn't make the payment, and if it's a claim made against Mr Gaiduk, Mr. Gaiduk didn't receive the payment. Avonwick received it, made by whatever the corporate entity was that Mr. Taruta used. But my learned friend's second point about the entire agreement is to say, well, we're not talking about a collateral contract here, we're talking about an understanding. So the suggestion appears to be that although you can't undermine the terms of this contract by reference to a collateral contract or any other agreement, you can rewrite the contract, because that's ultimately what he's asking you to do, by reference to something which doesn't even constitute a collateral contract. And again, I'm not saying that you could ever, or you would inevitably exclude claims in unjust enrichment by an entire agreement provision, because the law of unjust enrichment works on a different plane to the law of contract. It's gap filling, as I think Justice Gummo says in Roxburgh. So it does fill gaps. But the reason it's relevant, the entire agreement is relevant here, is because my learned friend's not trying to fill gaps, he's trying to rewrite, ultimately, or subvert a provision in this contract which makes it absolutely plain that the 950 million was paid, the basis upon which it was paid, was for the shares. And that's why the entire agreement has relevance. So that's, I think, all I was going to say about the contract. Now, according to my notes, I was going to take the court next to the judgment, but you've been to the judgment. I've said that the learned judge dealt, in my respect for submission, with the point I'm making between paragraphs 808 and 812, and again at 820 to 824. And I wonder if I can just very quickly take you back to the paragraph. So, the bundle tab 9 begins. So 810, I think, is where one, page 301. Maybe just picking up from paragraph 809, because one sees what Mr. Foxton says. Mr. Foxton submitted during the course of his oral closing submissions, if it is asked on what basis the 950 million was transferred, the answer is that it was not limited to an analysis of what obligations were owed under the Castle Rose SPA, since the claim of restitution not only permits a wider inquiry than that, but also enables proper account to be taken of the fact that $82.5 million came Mr. Gaiduk's way was not paid, and he knows and does not deny it. It was not paid for the interest in IUD. This means, Mr. Foxton QC submitted, that if Mr. Taruta is to get nothing back in respect of the assets for which it was paid, then equally there is no reason why he cannot demand his money back. And then this. There is, however, difficulty with this submission, and so with the unjust enrichment claim brought against the Gaiduk parties in the present case. This is that, as I shall explain, I struggle to see that there has been the total failure of consideration which is alleged, and so that there is the unjust factor which is alleged, and which is necessary if the unjust enrichment element claims to succeed. Looking at the Castle Rose SPA in isolation, Dargamo was entitled to the transfer of half of Avonwick's shares in Castle Rose in exchange for payment of $475 million, half of the total of the $950 million. This is what happened. Mr. Culver referred in the context to the fact that clause 2.4 of the Castle Rose SPA described the consideration as being in respect of the shares and as being set at 950 million, with the shares defined in Schedule 6 as being the shares in Castle Rose. There is no reference, Mr. Culver pointed out, to any obligation in respect of any assets other than the shares. The fact that the parties may have had some non-binding extra-contractual understanding or expectation of the sort alleged by the Taruta parties is immaterial, since, as Mr. Culver put it, there is no principle of English law which permits the court to find that sums were paid in respect of some understanding which was not an obligation under the relevant contract. Now, I accept that the last few words may be read as meaning was not, on the basis of some understanding which was not an obligation under the relevant contract. To the extent that that intends to suggest that you can only look to promissory obligations to see a basis, in my respect for submission, the learned judge erred. But his basic point, the basic point that he was making, including in paragraph 811, that this was paid pursuant to the contract Castle Rose SPA for a basis that hasn't failed, because the basis for the 950 million was the shares, is in my respect for submission completely correct. And then if I can invite the court to go to paragraph 819. And again, I'm going to show you paragraphs that I don't think my learned friend took you to. He took you to 818. He didn't take you to 819 and following. So if I can just read those. There may well indeed be a prior difficulty with Mr. Foxton's approach, although it is not a point on which it is necessary for me to state a concluded view. This is that it needs to be appreciated that what Mr. Justice Stadden had to say in Gaiduk, as relied upon by Mr. Foxton in support of the proposition that it is permissible to engage in a wider analysis, was made in the context of a case in which all the relevant obligations in consideration for which the price was paid were obligations which were contained within the contract. Although the obligations were not expressed as being referable to particular components of the price, the case did not, therefore, entail having to look at whether other obligations were owed outside of those contained in the contract. I suspect that was correct. Paragraph 820. Nor is the difficulty facing the unjust enrichment claim confined to those matters, since the authorities relied upon by Mr. Foxton in support of his submission that there need not be a total failure of consideration if there can be apportionment, are themselves all cases in which there is no contract in place at the time that the relevant payment was made. In the present case, in contrast, the monies now sought to be recovered by way of unjust enrichment claims were paid pursuant to a contract, namely the Castle Rose SPA. The fact that it was anticipated that other contractual arrangements would be entered into thereafter does not alter the fact that what was paid pursuant to an existing contract, and not, as for example in the case of the deposit cases, merely in anticipation that a contract would be entered into. And then paragraph 821, he refers to Chillingworth, Cobb and New Line to make that point. I'll just read that actually. Chillingworth, Cobb and New Line are essentially deposit type cases where monies were not paid under any contract but gratuitously. As for Guardian Ocean in particular, it should be appreciated that this was a case in which Mr. Justice Hurst had made a finding that the claimant's charged as payments of $600,000 expressed as payments under certain promissory notes were not in fact intended to be payments under those promissory notes and were not understood to be such payments. Now, just pausing there, the learned friend goes to that authority and he says this tells you that you can look wider outside of a contract in order to identify the basis for a payment. The court will have observed that the purpose of the inquiry by Mr. Justice Hurst in that case was to see whether these payments were made pursuant to a contractual obligation to make a payment or whether they were made in anticipation of another payment. What you don't have in that case, but you do have in this case, is a contract which identifies the basis upon which the payment has been made. And so when my Lady Justice Carr says to me, can you ever look outside the contract? I can't say never. But I can say that you wouldn't do it if what you're trying to do is to contradict a basis for the payment which is identified in the contract itself. It would be very odd to think that you could have such a thing, because why did the parties agree that that was the basis in the payment in the contract?
So the key factor is the express basis of payment in the contract.
Exactly, that's what we have here. And that's the difficulty that my learned friend seeks to get around by identifying a basis between other parties in relation to other arrangements. And just then reading on, it follows that it was not a case in which monies were paid pursuant to any contract. It further follows it was not a case like the present, in which the monies were paid pursuant to the contractual obligations contained in the Castle Rose SPA. And that's why, like I said, the learned judge nails the point. In my respectful submission, he does there as well. The learned friend took you to paragraph 822. But I don't think he took you to 823 or 824, and if I can just show you those. It is not appropriate to do what Mr. Culver described as the Taruta Parties inviting the court somehow to look through the terms of the Castle Rose SPA and decide in some abstract way that they have paid for something other than the shares in the Castle Rose SPA, in Castle Rose. And again, that's making a similar point. The truth is that without the alleged 2009 shareholders agreement being found to exist, there is simply no basis on which it can be concluded that any part of the consideration agreed in the Castle Rose SPA has failed. With respect, I don't entirely agree with the learned judge about that, because it doesn't seem to me you need, my learned friend, that doesn't seem to me, my submission, my learned friend is right to say that even in the absence of an agreement, if there's an understanding of some sort, that may in a different case be sufficient, but not this case where you have, as I say, a contractually agreed basis.
Sorry, my fault, I'm slightly behind you. So which bit do you think just overstepped the mark?
Where he says the truth is without the alleged 2009 shareholders agreement being found to exist. If that is saying
Yes.
that had to be binding, then in my respectful submission, and if that is saying it is only where you have a binding contract giving rise to a basis, then in my respectful submission that may overstep the mark. It may be that the learned judge was simply saying, if you had a contract which dealt with this, then that was okay. And it may be that why he was saying that was in the context of there being a Castle Rose SPA which had an express basis. So again, I'm not saying he's wrong. It's just it is with respect possible to misconstrue what he's saying, and to put it, I think, in the way that my learned friend put it, which is to say he seems to think that you have to have a contractually agreed basis for there to be a basis. I wouldn't go that far, but I don't think that is in fact what he is saying. And then we have this, as Mr. Culver also submitted. This is not a surprising result, since if parties design a bargain in a particular way and conclude a binding contract on that basis, it is not then open to them to claim a restitutionary remedy. And to the extent that what the learned judge has in mind is the fact that you have a contractually agreed basis for which the payment is made, in my respectful submission, that is entirely correct. Now, I can, I think, then move on to, I was going to say, to deal with the law. To some extent, I have foreshadowed that in my first introductory remarks. But I will say something, just take you to one or two of the authorities that I've mentioned without taking you to them. For the court's note, we deal with what we say is the relevant law here between paragraphs 10 and 43 of our skeleton.
10 and
43. Sorry, it's a big chunk. I'll give you smaller bites in a moment. That's pages 87 to 102. And we develop our submissions there under 4 broad headings, although there are really 3 categories. First, we develop the point about there being a general principle that a claim in unjust enrichment is precluded by a valid and subsisting contract. Secondly, we address there the nature and extent of any exceptions to that general principle. And then third and fourth, we have them as separate categories, but they're really about identifying whether it can properly be said there has been a failure of basis in claims where there is a valid and subsisting contract. So beginning, if I may, with the general principle that a claim in unjust enrichment is precluded by a valid and subsisting contract. Again, for the court's note, we deal with this between paragraphs 11 and 17 of our skeleton argument. That's pages 88 and 89. And can I just begin by taking you to, I think you will have seen this, but if I can just take you back to it, Burroughs Restatement, paragraph 306, that's Authorities, Volume 2, tab 15 at page 608. So volume 2, tab 15, page 308. And it's really, well, this passage, we've actually got this in our skeleton as well, page 88. An often overlooked but crucial element of the unjust factors scheme. I should say, you'll see it starts at page 32. It's really page 31 you want, and we can make that available. We've got it in court, and we'll copy it and get it across. The point about unjust factors being relevant. An often overlooked but crucial element of the unjust factors scheme, which one may regard as narrowing the gap between the common law approach and the civilian absence of basis approach, is that an unjust factor does not normally override a legal obligation of the claimant to confer the benefit on the defendant. The existence of the legal obligation means that the unjust factor is nullified, so that the enrichment at the claimant's expense is not unjust. It's difficult to see that there is enrichment, but this may be illustrated by a series of examples, and then one has the examples given. We'll come in due course to page 609, where the restatement identifies limited exceptions. But the court may want to glance at that now. There are some limited exceptions where the unjust factor overrides the claimant's legal obligation to the defendant so as to allow restitution. Explanation for these exceptions is not easy to pinpoint, but one might say there are situations where there is no underlying conflict between the reason for allowing restitution and the defendant's legal entitlement. Now, bear in mind, this section is not just dealing with contract, it's dealing with any obligation. For example, in Deutsche Morgen, there may have been a statutory obligation to pay the tax, and that's the sort of point that Professor Burrows, as he was dealing with, because allowing restitution does not conflict with the allocation of risk in the contract. And again, my learned friend says we're making it up, but he says we're importing all these limitations. With respect, it's not us who's doing it, it's the restatement. It does not conflict with the allocation of risk in the contract, or does not conflict with a contract.
Well, that's even more direct than
That's
allocation of
even
risk.
more direct. It's hard to think of a more direct point, because here it does conflict with the contract. And if you look at the examples, you will not find an example which comes close to the sort of case that the learned friend is asking the court here to accept. Nowhere near. Now, we also refer in our skeleton, and I wonder if I can just draw your attention specifically to this, to what Lord Hope said in his speech in Kleinwort Benson. That's at Core tab 5, page 88. So we didn't include, no friends said we were careful about not including authorities. There were occasional authorities perhaps we should have included. Arnold Benson may have been one of them, but we have the relevant extract at paragraph 13. Paragraph 13, this orthodox position, so we quote from Burrows. We say this orthodox position in England was articulated in Kleinwort Benson and Lincoln City Council. Lord Hope, setting out the questions for the House of Lords to decide, said that the third question was, did the payee have a right to receive the sum which was paid to him? That question was relevant as follows. The third question arises because the payee cannot be said to have been unjustly enriched if he was entitled to receive the sum paid to him. And again, if you ask yourself here, was Avonwick entitled to receive the 950 million paid to it? The answer is yes. Mkrtchan doesn't dispute that. There's a contractual obligation to make that payment. Can I just say, if the court would like this authority in full to be made available, we'll obviously make it available.
I think that would be helpful, thank you.
So that is Kleinwort
No.
Benson.
We don't need all of it.
No. Well, I'll give you as much as you'd like, but we'll make it available.
You can exercise your judgment as to what we need to see this in context.
We will. Or perhaps we'll exercise that. Sometimes less easy to do in these times, not in chambers, than others. Can I next take you to another authority to which we refer? Again, I did think you were taken to this. It's the, I mentioned it already, the DD Growth Premium 2 times fund against RMF market neutral strategies. You have that at Authorities, Volume 1, Tab 4, page 106. Now, for the court's note, we've set out the facts of this in paragraphs 15 and 16 of our skeleton. That's at page 89. There were 2 issues in this case. 2 issues in this case. The first related to whether payments made by a company whilst insolvent were lawful under Cayman law, and the board found that they were not, and one sees that at paragraph 57 on page 121. Although, as the board noted, this is at paragraph 59, the redemption itself was lawful and effective. Although the payments whilst insolvent were not lawful, the redemption itself was lawful and effective. You see that in paragraph 59. The second question that arose, more relevantly for our purposes, related to whether the company had a claim in unjust enrichment for the return of the money in question, and the board held that it did not, on the basis that the payments were made pursuant to provision of the Articles of Association. And we're looking at the judgment of Lord Sumption and Lord Briggs, which is a judgment with which the whole court agreed. Oh no, Lord Hodge dissented, and Lord Mance. You see this on page 124. So there's a minority judgment, but the majority judgment. If I go to paragraph 60, just picking it up there. In principle, money is paid under an ineffective, e.g. void transaction is recoverable. We can skip the authorities and then just go to F. As editors of Goff and Jones, the law of unjust enrichment explain, the ground of recovery in these cases is failure of basis. Transfer was not intended to be gratuitous, but the ineffectiveness of the transaction means that there never was any consideration for it. The same is in principle true if the reason why the transaction is ineffective is that it is illegal, or in this case the position is complicated by public policy against recovery of monies paid for an illegal purpose. And then paragraph 61 we have this. The present case is, however, rather different. The basis for the payment of the redemption proceeds is that the shares have been redeemed and cancelled, and a valid debt is owed by the company. That basis has not failed. On the contrary, the redemption was lawful. The shares have been duly cancelled and the nominal share capital of the company adjusted accordingly. The company's payment of part of the proceeds discharged pro tanto the lawful debt that arose in consequence. It is accepted by the liquidators that if it had not been paid, it could have been proved as a debt in the liquidation of companies. It follows that although the company acted illegally in making the payment, upon receipt it discharged the valid legal entitlement of the redeeming shareholder. It is fundamental that a payment cannot amount to enrichment if it was made for full consideration, and that it cannot be unjust to receive or retain it if it was made in satisfaction of a legal right. And then, as Professor Burrows has put it in his restatement in general, and it's really the bit that we've seen, and in this, the proposition is supported by more than a century and a half of authority. So the general proposition, fundamental that a payment cannot amount to enrichment if it was made for full consideration, it cannot be unjust to receive or retain it if it was made in satisfaction of a legal right. And that is precisely the position here. And with respect, I'm not sure on what basis that can be disputed. Now, as we accept, there has been some discussion in Roxburgh and by the academics to the possibility of there being an exception, and indeed Professor Burrows accepts this, of the possibility of an exception to the rule that a payment made under a contract or a payment made in respect of a contract can nonetheless be the subject of a claim in unjust enrichment. As the court saw, and as you've heard from my learned friend, before the judge, not my learned friend, but his predecessors, Foxton, was relying on 4 authorities. He was relying 2 in this jurisdiction and 2 in Australia. In Australia, it was Roxburgh and Mann. That's paragraphs 782 and 783 of the judgment, page 294. In this jurisdiction, the judgment of the Supreme Court in Barnes and EastEnders, that's at paragraph 784 to 86, and also the decision of the Supreme Court in IEG and Zurich International, the Fairchild Enclave cases. Before this court, my learned friend only relies on, in my respectful submission, rightly, doesn't rely on the Fairchild cases, the IG cases. He focuses on Roxburgh and Barnes. He doesn't rely on Mann for good reason, and that is because, as Albie is submitting, Mann is against them and supports our position. Now, I was going to begin by taking you to what Burrows says about the limited exception, but perhaps you've seen that I don't need to take you back. I'm very happy to take you back to it. Authorities, Volume 2, tab 15, page 606. Tab 15. That's where it starts. That's where this discussion starts. Page 609 is where he identifies the limited exceptions. And this, recall, is what I showed you. There are some limited exceptions where the unjust factor overrides the claimant's legal obligations. And it's the point on the next page which I've already identified and drawn the court's attention to. It must not conflict with the contract. And so I'm just pausing there. The question which, if I may call him Professor Burrows, as he was then, poses here is this. Is the claim to unjust enrichment one that produces a conflict with the defendant's legal entitlement under the contract? Or does it otherwise cut across a contractual allocation of risk? If it does, there is no scope for the exception or for any exception to operate. If not, then potentially there is. And I will be submitting, and indeed as I've already foreshadowed, when one looks at Roxburgh and Barnes, it is very clear that allowing the claim did not cut across any contractual entitlement of the parties and did not conflict with the contractual allocation of risk. Can I put it this way? That is the way the academics who want to find some basis for supporting it interpret it. But as we submit, the same cannot be said about the claim made for restitution in the present case. Now, I was next going to take the court to Roxburgh. I wonder whether the court would indicate what time you're happy to sit for, because I appreciate it's been a long day, and I'm in a way I said what I wanted to say in the first 20 minutes.
We're happy to sit till 4:30.
I'm very grateful.
We can catch up our
Thank you.
time this afternoon.
Can I invite the court to go back to Roxburgh? And I'll take this. Mkrtchan's taken you through some of it, some speed. He explained the facts. Effectively, it was like a VAT payment. You make the wholesaler pay a license fee, but the wholesaler then, in a sense, recovers it from the retailer, who recovers it from the smoker, or the person buying it from the smoker. And in that way, the consumer lands up paying a tax on cigarettes. And Mkrtchan explained that it was rather disguised taxing for which there was no jurisdiction, and so it was struck down. And again, Mkrtchan made the point that you basically, it was a debate between two undeserving parties. The wholesaler had received the tax and not paid it on. The retailer had recovered the tax from the consumer. And the question was, who should get the money, or should they be able to keep it? But it is important to understand that the basis upon which the tax was calculated was clear and set out in contractual or in documents that parties to the contract had to sign as a prelude to signing the contract. And it didn't relate to the value of what they themselves were purchasing, but it actually related to the wholesaler's last month's sales, which the court thought to be relevant and significant because, again, it showed that this was not part of the contractual allocation of risk. It was an externally imposed payment obligation. And the fact that it didn't relate to what they were actually buying reinforced that conclusion, that it was an externally imposed payment obligation, and so not part of the contractual allocation of risk. But can I just identify the paragraphs where one finds the working out of how it came about that the parties agreed and had to pay this tax? Paragraphs 8 to 10 of the High Court decision make the point about how the license fee was established, being set out in a statute and relating to previous month's sales. That's at page 452. I'm not going to take the court through all of that. But what does matter out of this, and this emerges from paragraph 9, is that it was necessary for tobacco retailers to publish wholesale price lists from which the license fee might be calculated. That's at paragraph 9. It's also in the federal court judgment at paragraph 16. We have that in the authorities bundle. I wasn't going to turn it up at pages 417 to 418. Sees that at paragraph 9. And this list, which the tobacco, the wholesaler published, also identified for any retailer seeking to buy tobacco from Rothmans what the cost was and what part of that related to the license fee. Again, paragraph 9. In addition, any retailer wishing to deal with Rothmans would need to sign a form of request. This is paragraph 10, I'm picking this up from. Would need to sign a form of request for a commercial trading account, which referred to Rothmans' wholesale price list and which made express reference to the fact that this included that duty. In addition, Rothmans' standard form invoice also specified for each product the wholesale price list for 1,000 cigarettes and separately the tobacco license fee amount. And that's paragraphs 11 and 12. In other words, the fact that there was a price for the tobacco and separately a license fee was very much the basis upon which the parties contracted and was reflected in the documents by reference to which the parties contracted, as well as in the invoice itself. And this was of relevance for the majority, not least because, as Justice Gummo found, there was not here a single contract, but a series of contracts that came into effect as a result of a course of dealing, which would have taken these matters into account. And one gets that at paragraphs 43 and 44 at page 463. I'm very happy to read that to the court, but it is marked, and one sees the point there made. And again, as I say, this is material to the way in which Justice Gummo analysed it, because he was concerned that the payment of the license fee should be regarded as something identified by the contractual documents, and indeed by the contract. If I can invite you just to, if I may, the court to go back to paragraph 12 on page 453. This is in the majority judgment, if I can put it that way. One sees about 4 lines in, Chief Justice Gleeson, Justices Gordon and Hayne express it this way: the tax was an ad valorem tax on goods. The value of the goods had to be distinct from the tax. The tax was to be passed on to the retailer and was to form part of the cost to the retailer of the goods. But in the documents which form part of the ordinary course of dealings between the appellants and respondents, and by reference to which their contractual rights and obligations, liabilities are to be determined, the parties distinguish between the wholesale price, tax, and net cost to the retailer. In my respectful submission, that is of some relevance when one considers my learned friend's submissions as to what Roxburgh allows you to do. Roxburgh is not a case where it is undermining or inconsistent with the contractual allocation of risk. Now, my learned friend said,
although it is a case in which the retailer's payment discharged an obligation which they were under pursuant to the contract.
That is, with respect to your lordship, is entirely right. But that is again why the court was very concerned to say that there was a failure of basis in relation to that part.
Yes.
My lord is right. The point about discharging an obligation doesn't work as being a complete defence. Doesn't work if the whole basis of the contract fails. But where the payment itself, identifies the basis for which it is made, and
that basis has failed.
Hasn't failed, then one has a difficulty. I was next, I think.
Sorry, so just going back on that. So, my lord says, so the rule that you were taking us to about effectively that you cannot have an unjust enrichment claim if the payment is made.
In discharge of an obligation.
Yes, is not an answer, a bar.
It's not totally unqualified.
It can't be totally unqualified if the whole basis of the contract fails. So if one party makes a payment to another, I mean, you could take it as a promissory consideration. I make a payment on the basis that there's going to be an inauguration of something or someone, and I paid to stand in a particular position, and there is a contract which says you have to pay X for that, the inauguration is cancelled. So the basis of the payment disappears. One can quite see in that situation, there is a failure of consideration, a total failure of consideration. There you have a claim. The point which is being made by the academics and by the authorities relates to a situation in which the basis for which that payment is made hasn't failed. And again, I suppose it goes back to the question whether you can substitute the contractually identified basis for the payment for some non-contractual basis for the payment.
But in Roxburgh, there were two separate payments.
Indeed.
And the basis for one of them had failed, but not in respect of the other.
Correct.
So no question of recovering the actual price of the goods.
Exactly.
All the question was the recovering the tax, which turned out not to be payable.
Correct. And with respect, correct. And the difference between Justice Kirby and the rest of the court was whether you could say there were two severable parts of this as opposed to one.
Now, as Mr. Cray said, well, the fact that the tax was separately identified is simply an evidential point. You say, no, it goes to the heart of whether or not the basis which is argued contradicts what is in the contract.
Precisely. All the points which the learned friend said were either evidential or things which we were bringing into which were factual, externally imposed. The learned friend said I was bringing in externally imposed in as a factual point, but it had nothing to do with the law, because this is on the basis of his principle that if it's unjust, it's unjust. With respect, that's not the way the law here works. The fact that it is a severable element is critical.
Contractually agreed as a severable element, as it were, on the face of the contract.
It doesn't undermine the contractual allocation of risk. And the externally imposed goes to the same point. It doesn't undermine the contractually agreed allocation of risk. Because it was externally imposed, they were only paying this because they were required to pay it. It wasn't part of what they'd agreed. And one sees that, again, I don't think you saw this, but paragraph 13 as well. The amounts paid by the appellants to the respondent in respect to the tax represented a distinct part of the consideration for the tobacco products purchased by the appellants. They were treated by both parties to each relevant contract as separate from the wholesale price of the goods sold, that price constituting the value by reference to which the amount of the tax was determined. And the tax, being a tax on goods, was of such a nature that it was not intended to be borne ultimately by either the appellants or the respondents. And again, so again, just to be clear, I know this is a slightly jerky type of submission. Roxburgh is a very controversial case. Those who say it's wrong, but those who support it only on a very narrow basis, that it isn't interfering with the contractual allocation of risk. Which is why when the learned friend says that I'm importing those requirements, with respect, I'm not. I'm really just mouthing the way in which the academics who say you shouldn't disregard this have sought to justify its existence or it having any effect.
Are you planning to take us to the competing?
If you'd like me to, I will.
They're in your skeleton.
They're in our skeleton. I was going to take you to Goff and Jones and the Beats and Recant, partly because Jeff is a friend of mine and I always enjoy
showing him changing his mind.
Poking at him. Paragraph 16. The learned friend, I think, is taken to paragraph 16. That's where you get the failure of basis principle set out. And as I've gone to some lengths to say, I don't dispute that. I don't dispute that this is a principle of law, and I don't dispute that it's not limited to the promissory consideration of the contract. Same is true of paragraph 17. The learned friend, I think, took you to paragraph 20. And the learned friend said that this was a paragraph which showed that there was no difficulty in unjust enrichment, undermining, subverting contract. But as he read it, with respect, in my submission, it was saying exactly the opposite. The point that was being made here, and in my respect for submission, my learned friend may have appreciated it as he was reading it. The point that was being made here is that the court was dismissing another way of putting the claim, which is to say there was an implied or an express agreement. It then found there wasn't an implied or express agreement, but it said, well, the law of unjust enrichment is there and it may be available. But what it wasn't saying is that by relying on the law of unjust enrichment here, you are cutting across and subverting and producing a result inconsistent with the contractual agreement made by the parties. Paragraph 21, in my respectful submission, is important. It accords with the basis of dealing in contractual arrangements between the appellants and the respondents to regard that part of the net total amount of each invoice referable to the tobacco license fees as a severable part of the consideration. And one sees what the court is actually saying is that it goes with the grain of the contract to do this, which has failed. There is no conceptual objection to this for the reasons already given. The tax component of the net total wholesale cost was treated as a distinct and separate element by the parties. It was externally imposed. It was not agreed by negotiation. It was not like the discounts, which might differ between retailers, just as the wholesaler's price would vary from time to time in accordance with market conditions. To permit recovery of the tax component would not result in confusion between rights of compensation and restitution, or between enforcing a contract and claiming a right by reason of events which have occurred in relation to a contract. And again, in my respectful submission, the last few lines are significant because the majority, or Justice majority here, were very concerned to say that they were not doing anything which was inconsistent with subverting or otherwise interfering with the way in which the contract worked. So it was really paragraph 21, not paragraph 23 that I had in mind. So we say that this is a key part of the reasoning of the majority. The tax element was dealt separately from the rest of the price by the parties, as reflected in the contractual arrangements made by the parties, and further that permitting a remedy here would not result in confusion between what was required by the contract and what was provided for by allowing the unjust enrichment claim. And then just going on to Justice Gummo, I think took you to this, it begins at paragraph 32. The first part of his judgment is addressed to questions of unjust enrichment generally, and just so that one sees this, paragraph 75, I think this is picked up later by Lord Toulson, paragraph 75 at page 474. It's earlier on, paragraph, I'll find it for you. But paragraph 75 is the paragraph I wanted to show to the court. The action to recover the monies sought at 474 by the appellants after the failure of the purpose of funding Rothmans to renew its license may be illustrative of the gap-filling and auxiliary role of restitutionary remedies. And you will recall, in my introductory comments, I made the point about the subsidiarity nature, or subsidiary nature, which is the right expression is, of unjust enrichment when compared to contract. It is a gap-filling part of the law of obligations. Important, but gap-filling. And certainly not intended to subvert contracts. Paragraph 101, Malone took you to this, page 484. Justice Gummo makes clear that there being a failure basis doesn't depend on there being a contract or consideration being contractual in nature, and that must be right because, for example, in the deposit cases, one has a failure of basis in the absence of a contract. So one doesn't need a contract to have a failure of basis. Paragraph 104 on page 486. Justice Gummo explains why in the facts before him there was a failure of consideration. And again, my learned friend showed that to you, and there's nothing further I'd like to get out of that. Paragraph 109 on page 486. No, 109 is on page 487. One sees there that Justice Gummo stresses that in the case before the court, the parties had contracted not only for the supply of tobacco products, but also in light of the provisions of Section 41 of the Act, with respect to the renewal of the wholesaler's license and the funding for that to take place, and that as a result, while that is understood, the very form of the transaction indicate that the payments made by the appellants can be broken up. That's all I was going to say about Justice Gumbo. Justice Kirby's judgment begins at page 488. I've already made the point that he dissents. The point of dissent really was about whether the payment obligation could be broken up in the way that the majority thought. Justice Kirby didn't think that one could do that. It's really paragraphs 165 and I think 173. They begin at page 506, which are particularly relevant. I can just show you these paragraphs just because, perhaps before we finish, just because in a way they state the general proposition. The final ground upon which the retailers claim relief was for...
Sorry, this is where?
Page 506. Paragraph 165.
160.
The final ground on which the retailers claimed relief was for the restitution on the basis of failure of consideration. The payments made by the retailers to the wholesaler were made in discharge of express contractual obligations agreed between them. The wholesaler discharged its part of such obligations by supplying the goods in question to the retailers. Those goods were supplied in accordance with an agreed price. The price in each instance subsumed and included within it various component parts, only one of which was that of the license fee. No doubt it also included component parts for notional discharge charges for acquisition of raw materials, tobacco product, warehousing, packaging, processing, transport, overheads and the like. The separate appearance of the component for the tobacco license fees on the wholesaler's invoice was doubtless convenient for accounting purposes. It permitted the ready aggregation of the license fee, then thought to be payable under the Act, but the legal obligation of the retailers to the wholesaler was to pay the price of the goods in full. This was a single aggregate amount, referable to each occasion of supply. Then just picking up in paragraph 166, in the foregoing circumstances, it is impossible to assert that there has been a total failure of consideration. Individual contracts made between the wholesaler and retailer were uncontestably valid. They were not ineffective, nor were they terminated. Far from attempting to terminate the contracts for the supply of goods by the wholesaler, the retailers actually accepted the goods in every case. They unsold them to consumers, thereby recovering the component for license fees about which they now complain. The law of restitution only rarely operates in the context of an effective contract. The present, in my opinion, is not a case that falls within one of those recognised exceptions. The retailers nevertheless claim recovery to recover under some unifying principle of restitution for unjust enrichment at the expense. They did so on the basis that, notwithstanding that consideration had not totally failed, some part of consideration could be separately identified a portion and then seen as having failed. This submission should be rejected. By the terms of the contract between the wholesalers and the retailers left the obligation of the wholesaler to pay the tobacco license fee to the government entirely out of account. It was unsurprising that this should have been so. At the time the contracts were agreed to, the obligation to pay the tobacco license fee arose not by any contractual agreement at all, but by the operation of statute law, namely pursuant to the duty imposed by the Act. As the majority in the full court explained, the retailer could succeed in a claim for restitution on the grounds of failure of consideration only if the wholesaler was bound to them by the promise to pay the amount identified as being for the license fee, and such promise was wholly unperformed. In light of the then understanding of the obligations of the Act, it borders on the surreal to suggest that the wholesaler promised the retailers that it would pay the license fee to the government, in default of which there would be a failure of consideration in respect of that part of the price. Not only does this hypothesis defy the express terms upon which the parties traded with each other, it also contradicts the historical fact that the obligation of the wholesaler to pay the tax was an obligation imposed on the wholesaler not by a private contract but by the terms of the Act. I therefore agree with the full court that the basis for asserting the right to recover at common law was not established. The monies were not hadn't received by the wholesaler to the use of the retailers. Properly analysed, they were hadn't received in discharge of contractually stipulated price, payable in full in exchange for the supply of the specified goods were duly delivered. So one sees there the point of difference between Justice Kirby and the rest of the court. Justice Kirby did not think you could treat as severable the obligation to pay the price, whereas the rest of the court did. And that was fundamental to the basis upon which they decided. And that in my respectful submission, is important. I was kind of come next onto academic commentary, but
What, paragraph 173 of Mr. Justice Kirby? Justice Kirby.
173. As a matter of legal policy, the court should be extremely slow before introducing entitlement to restitution in a case where total failure consideration cannot be
I
shown.
don't know. Do you rely on this?
Well, I do rely on that, but I was going to show to you in Man. Once you get to Man, one sees, I don't know whether there's a deliberate stepping back from Roxburgh, but they're very clear that unjust enrichment should not interfere with contracts, very much for this sort of reason.
But the point in 173 is about being slow to find a failure of partial consideration, or is it broader?
No, that is. Can I say this about that? When we get to bonds, Lord Toulson touches on the fact that there is a big academic debate between total failure of consideration and partial failure of consideration, or failure of basis, actually, total failure of basis and partial failure of basis. And he says, well, the academics can debate this, but in bonds, there is a total failure of basis because there never was a proper appointment of receivership. To some extent, when you are on the failure of basis type argument, you can always avoid a debate about whether the failure of basis is total or partial simply by characterizing that which has failed
As the whole.
as the whole, which effectively is what happens in bonds. Now, my learned friends haven't really gone here, but they could, and perhaps if one asked them, they would say this is a case of total failure of basis, not partial failure of basis, because what has totally failed is either an agreement or the actual transfer of the assets, the agro holding and the net asset. So I don't think I don't specifically rely on the total failure consideration versus partial. In my respectful submission, what he said there is absolutely right. And the reason I don't rely on it is because I anticipate that if I did say we're dealing here with a partial failure of basis, my learned friend could say, well, you've misconstrued how I would characterize the basis which has failed, because the whole basis has failed. That is to say, there wasn't a transfer of net or agro, and that is the basis, and all of that has failed. So I hope I'm making myself relatively clear at this late stage in the afternoon.
Thank you very much, Mr. Rabinovitz. I think that's an appropriate time to muse on what has already been said. How are you doing?
I'm doing well. I will finish within my allotted time. Partly because I'll be repeating a lot of what I've said before. I've made my key points, and my learned friend did a lot of the heavy lifting in terms of the authorities.
Thank you very much indeed. 10:30 tomorrow then. Thank you.
After I finish my introduction, but I find that if I go to the cases and read through what you've already read through, I can take up some time.
Yeah.
Oh yeah, of course.
I have 2 hours.
Yeah.
I imagine they leave all their equipment overnight because it's carrying on tomorrow.
I thought you were going to sit down after half.
Yeah, that's.
Move on.
I thought you were going to sit down after
Well,
half an hour.
I did say to you, in a way, you know, you get excited. You think, well, this is what I think.
Yeah.
You sort of spill it all out. You go, what am I going to say now?
Yeah.
Because, I mean, you probably feel the same. In this case, it doesn't when you get into court, you think I can state what I want to say in 10 minutes. And I have to stand there and talk.
I didn't.
Right, bye, Lucy. Bye.
It's mask wearing. Mask wearing in court, isn't it?
Yeah.
Oh, it's horrible, isn't it?
I don't know what happened in Gibraltar.
Oh.
Actually, no, I'm going to ask. Yes. Which in case you managed to
Yeah. Sorry, it's like a total pain.
No, it'll